Good morning, everyone. Thank you for joining us this morning for our Commission staff workshop regarding the Public Service Commission's review of its Code of Regulations in Chapter 103 of the South Carolina Code. And we are conducting these reviews pursuant to South Carolina Code annotated Section 1-23-120J, subsection J. Our agenda this morning, first and foremost, is for me to introduce myself. I also want to make you aware of our court reporter this morning who has graciously attended and is recording everything that's being said. And her name is Miss Cindy First. I think at least one of you know her. Charlie, I think that you know her. Charlie Terani, I think you're familiar. And Sam and Roger and Alex, it's possible that you know her too. But if she doesn't know you or you don't know her, before you speak, if you would, please identify yourself. Okay? So the process for this workshop today will be similar, very similar to the workshop from the last one that we conducted regarding the 800 series of practices and procedure regulations for the commission. We are going to start according to the agenda. Everyone should have an agenda. The second item on the agenda, we will hear a short summary of comments filed by Blue Granite Water Company. Next, short comments filed by Southwest Water Company Utilities. Thereafter, a summary of comments from the Department of Consumer Affairs. And finally, summary of comments from the Office of Regulatory Staff. So we'll start with you, Sam, if you would identify yourself, please, and then proceed with your presentation.
Yes, Jocelyn, good morning. Thank you. This is Sam Wellborn. I'm with the law firm Robinson Gray, Steppen Lafitte in Columbia, representing Blue Granite this morning. And I will launch into our relatively short summary of the comments filed. Primarily, our initial comments addressed our proposal to strike regulations 103.552 and 103.750, subsections B1. The reason for that is there appears to be some overlapping regulation between the Department of Health and Environmental Control in South Carolina and the Public Service Commission related to these minimum pipe size and water main requirements. The DHEC regulations are a fair amount more detailed and in some areas conflict with the Commission's regulations on these issues. As one example, interceptor tank systems with interceptor tanks can have smaller mains than those provided in the Commission's regulation. It also presents the question as to whether older infrastructure should be grandfathered under the regulation that was compliant with the regulations at the time and is still providing good service to customers, but isn't necessarily compliant with these PSC regulations that, again, appear to conflict with DHEC regulations in certain places. It's also worth recognizing, I think, here that 103.551 and 103.751 both require or recognize deference to DHEC's regulations when it comes to these matters. And so there's sort of a recognized conflict there, and the DHEC regulations are much more detailed, as I mentioned. So we think there's a good reason to go ahead and strike these two regulations. On reply, we generally agreed with the comments of Southwest Water Company related to regulations 103.535.1, 103.735.1, and regulation 510 for the reasons stated by Mr. Tarini, and I'll defer to him in his presentation for that. Related to the Office of Regulatory Staff's comments, that language be added to 103.735.1 and 103.535.1. We would propose that utilities be permitted to leave a door hanger for the notice. Understand that practice is pretty common with other utilities and would minimize person-to-person contact. We also, like Southwest, disagree that there should be an additional mailer. There are already 2 certified notices that go out prior to disconnect. And because these generally relate to non-pay disconnects, the funds to cover the additional mailings would be covered by other customers. So they wouldn't be covered by the customer actually being disconnected. Those costs would be spread out among sort of the good paying customers. We're also concerned that the mailer, as provided in the proposed reg, wouldn't arrive at the residence in time for actual notice. So the Postmaster General recently announced that first class mail would have a 5-day standard. I believe the proposed language in the regulation would require mailing 3 days in advance. So there's really no way to guarantee that it would get there in time. So just flagging some concerns and issues with that piece. And Jocelyn, I think I have a question for you if I'm permitted to ask questions. We had reply comments to the consumer advocate related to the rate case application recommendations. It seems that those recommendations in our reply might be more appropriate for the next or the workshop in April related to 103-823. I can go through those now if you would prefer, or we can hold those if you'd like.
Um, I read your comments too on that. It's on April 5th.
That's right.
Yes. So you can actually now I think the purpose for the consumer advocate mentioning Sam, let me find the reg right quick. I think there's information in the 500 series about applications that are filed.
There are, and in Article 7 as well. And so I guess one issue that we'll need to work out should these regulations be revised or reviewed by the commission is whether they will still belong in Articles 5 and 7, or whether there will be more generic requirements that sort of supersede those requirements. And I see Roger's camera on it. I can hush and let him weigh in here if that would be helpful.
Yeah, please.
Yeah, no problem. Thanks, Sam. I agree that there's some overlap there. And obviously, as Jocelyn said, because there are two sections about applications, I was going to just briefly mention those today. So if you want to do the same, but I'd be also happy if we just want to defer those to the April 5th conference or workshop, because I do agree they're probably better to be discussed there. I'm sure there'll be more comments from other parties there as well.
Well, why don't we do that, everybody, so we're efficient with this, and then we can also talk. Perhaps everyone, we can issue us an email that says that basically will cover the rate application, minimum filing requirement, dialogue, and also connect these sections like the water, sewer sections that mention rate applications. Just include all of that in the April 5th workshop. I think that's the most efficient way. Thank you for bringing that up, Sam. And thank you, Roger.
Great, thanks, Sam.
Yeah, thank you. And I just have one last thing then. So we'll skip ahead out of that rate case stuff. The regulations 103-532.1 and 103-732.1, or rather 0.2, which both relate to customer bill forms and a proposal by the Consumer Advocate's Office. The company Blue Granite believes that it would really not be practical to adhere to a 12-point font size for customer bill forms. It would either mean eliminating some relevant and important information that customers should have from the bill, or substantially increasing the length of the bill, which would increase printing and postage costs. It's also true that multi-state utilities such as Blue Granite and other companies, we won't speak for Duke here, but other multi-state utilities use standardized bill formats, which saves printing costs and processing time, which again, inures to the benefit of customers. And so making those changes in South Carolina would result in cost increases, both in terms of the process and the form that producing those bill forms by utilities take. So we would oppose sort of the 12-point font size recommendation for customer bill forms. The Commission's regulations already require that bill forms be submitted along with rate case applications. That requirement is already in the regulations. And Blue Granite itself had done so in the 2019 rate case. And we think the provision within a rate case context provides parties an opportunity to provide utility-specific feedback on bill forms during those proceedings, which can include things like modifying bill font size and content and that kind of thing. So Jocelyn, I think that wraps up my comments or my summary of comments, unless there are any questions for me.
Okay, Sam, I just had a few questions, please, sir. So I understand your client's suggestions about 103552 and 103750B1. Um, I wanted to ask you just a question for myself. At the bottom of the pages of your first page from your filing from March 9th, 1, 2, 3. Oh, I think I just wanted you, Sam, would you give me an example? The part of the sentence reads, four sentences up toward the end, beginning with the word otherwise. It says, otherwise may unnecessarily add to cost or operational risk in certain cases. Can you think of an example that you could tell me? Is it
Yeah,
because, were you trying to say there at some point, um, you mentioned that the PSC's regs conflict with DHEC's regulations in certain areas. So the operational risk, I guess, would be investing in perhaps what the PSC regs could state at that point, and DHEC's regs had been amended. So the company would end up taking that risk by following the PSC regs, and then might have to invest more funds to conform to DHEC regs. Am I off base with what you were saying there?
yeah. No, you're right on the money. So that's one example, and I think the fundamental problem is the conflict between the DHEC regulations and the POC's regulations, particularly as related to the minimum pipe size, pipe diameter. So I mentioned that one of the DHEC's regulations on these matters are somewhat more detailed, and there's one example where systems with interceptor tanks can have smaller mains. And that isn't reflected in the PSC's regulations. It's also true that some of the older systems may not comply with these minimum size requirements, and so there's a question as to whether those would be grandfathered or whether they should be made a priority for replacement. So that was something that sort of came up in our review of this issue. But yeah, I think you unnecessarily add to cost. So when you have a DHEC regulation that provides a minimum size requirement and customers are being adequately served by that, and then you have a different, whether it's higher or lower, I guess if it's a minimum requirement, if it's a higher minimum requirement provided by the PSC, there's a question of whether that additional investment is worthwhile for customers. So it's just some of the issues that sort of came up in our review, and I think if this goes to a rulemaking, we could dig in. We would have more time to dig in and provide more details. But these are some of the issues that we identified on our first pass.
Okay, and Sam, just some other, just for my questions that I have. So regarding your reply comments, thank you for filing those. The second page regarding the Office of Regulatory Staff's additional notice requirements for disconnection, and your client included language regarding the door hangers, and those are pretty stable. Has it been the experience of your client that once those are hung on doors, customers see them, they're visible, and have they been effective? Basically, notifying the customer of an impending possible disconnection or termination of service.
Yeah, and so I don't have independent knowledge of that. I would have to ask the client that question and maybe file a follow-up letter if that's okay.
No, yeah, sure. I was curious about it.
Yeah.
Mm-hmm.
Yeah, so practically, I would have to ask. I think in general that it's relatively common practice both in the electric and I assume in the water world. It's common in my understanding in the electric world for door hangers to be left. Considering somebody has to check their mailbox to get a mail notice, presumably they're going out the door to get it. And I don't say that to be facetious or whatever, but to practically get some data on your question, I'd be happy to check back in with the client and get some more information on that. I wonder. I wonder whether and to what extent Blue Granite has experience with door hangers. But again, if they don't, or if they do, I can ask that question.
I ask only because sometimes I see things and sometimes I don't, depending on uh, when I leave. Sometimes
Yeah,
it's dark,
same here.
and when I get back home, it's dark, and so I miss things sometimes for a couple of days.
Yep.
Now, Sam, thank you for indulging in this dialogue with me. Let me ask you something else. How effective does your client or clients do they use text messages to notify people of
They Yeah, they do. So, and I can't remember in this moment what the name of their app is, but they have an app that both provides messages through the app. I believe it's called My Utility, through the app as well as through text messages, and there's also a phone call element, as I understand it. So they have sort of a multimodal, communication ability with their customers when it comes to outages or impending disconnects, I assume, and that kind of thing. So that's a great point. They have other ways and other modes of getting in touch with their customers.
yeah, I don't know. I
Yeah.
mean, our regulations are, several decades. They've been in existence for several decades, so that might be something else for us all to think about. Electronic notification too. And then Sam, one other thing. I'm not trying to. I know that Alex would do a great job presenting his position. Were you? I saw where ORS used the word alternatively for the third. It's for the notification not more than 3 business days. But you think even if it's an alternative, that's the way I read it. I could be reading this wrong. It's either 2 business days prior to termination, I think by telephone, or the company could not more than 3 business days. But I can ask Alex more about whether it was one or the other. And if
Yeah,
it's
no,
one,
you're right. I do think that the use of the word alternatively there is helpful. But when you make the alternative to telephone or in-person contact uh, via mailer, it's sort of like which is the best option, which is the most cost effective, and which adequately provides the notice to customers. And given the general sort of question mark when it comes to the reliability and consistency of the timelines for first class mailing. We had some issues with that, I guess, or at least wanted to wave the flag.
okay.
And I don't know whether a door hanger could be construed to be in person contact, which I think is one of the options here. Whether that would rise to that level, and so sort of to close that question for us, we propose this additional language to sort of close that loop. But yeah, you're right. I think the alternatively there, and again, we can ask Mr. Knowles and ORS what their view is, but I do think that does provide optionality.
Thank you so much. One last thing, I promise. Okay, so I'm going to argue the other side for regarding the customer bill. Okay, Sam. So you mentioned that it is a requirement that when a rate case is filed, the utility has to file its customer bill form with the application. And you said, one of your reasons was, well, these bill forms can be reviewed in each application. Sam, what if a company doesn't file a rate case for another 5, 7, or 8 years? Then what?
Yeah, well, I think I had sort of two responses to that. One would be, if someone's bill form is out of date for some reason and really needs to be reviewed by the commission, I think that could be accomplished through various methods, whether it's a complaint filed by the consumer advocate. I'm not advocating for that, or I'm sort of thinking on the fly here, thinking out loud, which is dangerous, but I think a red flag filed with the commission could be a way to handle that. Um, the I guess the second part of what I would offer is that it was reviewed in the most recent rate case, whether it was 5 years ago or 6 years ago. Font size as an issue is not something that necessarily changes from one year to the next. I think one's view on what the font size in a bill form should be um, isn't something that goes stale pretty quickly, if that makes sense. Um, but yeah, I think if someone's bill form, if utilities bill form were really out of date, if it didn't include the web address, for example, of the utility, or didn't include some novel information that maybe should include. There are ways to deal with that outside of a formal regulation. Um, I don't. That's my own view.
Thank you.
You know,
Yeah.
all right.
Those my thoughts as I was reading. You
Yeah.
did an excellent job. Appreciate it. Thank you, Sam.
Sure. Thank you for the time.
Yes, sir. Okay, we're going to move next to Southwest Water Utilities. Charlie Terrini.
Good morning.
Good morning.
Thrilled to be joining you from my satellite office this morning. The Southwest Water Utilities comments are fairly straightforward. We made two recommendations initially. One is already been discussed at some length, which is the doing away with the 30-day certified mail notices that are required in the current regulation. And, our reasoning is fairly straightforward. A lot of people, when they get a certified mail notice, figure it's not something good, and so they don't pick it up. And so these notices not only are costly, but they're ineffective. What results is a customer with a delinquent account getting deeper and deeper in a hole and accumulating fees on top of that. And it's not a good situation for the utility. It's not a good situation for the customer. I will go ahead and say that I agree with Sam's comments that the ORS recommendation of a 2 to 3 day prior extra notice is also, I think there's some difficulty with that. It certainly can't be mailed. This is, as I listen to this, it occurs to me, we're doing a pretty sweeping regulatory review here. There's a lot of ground we cover. And it may be that some of these issues, like disconnects, require a little more discussion that we can give them in this forum, and maybe should be broken off and don't necessarily need to be, and my client's probably complaining right now because they want to do away with this certified mail, but it may be that we need to discuss them in a little more depth and in a separate forum to figure out what is appropriate. Nobody wants people to be surprised by a disconnect, for sure. I'm sure the commission doesn't. I'm sure the utilities don't. But I don't know that we've got a workable end solution right now if we're looking for some extra notification. The other initial recommendation we made, I think, is pretty straightforward and doesn't seem to be controversial, which is that we allow utilities to keep their records available for inspection in the state instead of in a physical office. This is a regulation that's enforced by exception. Most everybody's requesting waivers of it, and so I think it would just make sense to go ahead and change it and reflect the modern reality that people's records are probably stored on a server someplace, and we're not even quite sure where that might be. We responded to the Consumer Affairs Department's recommendations regarding bill formats. I don't know that it's practical or constructive to start making. First of all, I'm not aware of any complaints that have been brought to the commission about anybody's bill formats. Most recent rate case I was involved in, the complaint really involved that people weren't receiving their bills by email, electronically, and I think we ought to recognize that we're sitting here, discussing whether to do 12-point type and bold-faced letters and all caps or not all caps. And SCNG is pestering me to allow them not to send me a paper bill. So we're making regulations about something that may become obsolete at some near point in the future. I would also reiterate companies like Southwest Water use a national platform for their billing services, and that to start making state-specific changes to it is going to be costly and complicated. Um, that that really concludes my comments.
Thank you, Charlie. So I've made a note, and if everyone agrees, my first note that I made regarding future discussions is that we're going to include rate application discussions on April 5th, no matter the series of chapter 103, meaning whether it's the 500 or 700, we will discuss all of that at one time and have
Yes.
subsequent discussions if necessary. And then you just mentioned a separate forum on disconnects, and I've written that down as another action item. Um, Charlie, I did have some just general questions just to get your thoughts. One that I wrote
Sure.
down regarding the additional notices and the 30 days for sewer, because it involves the Department of Health and Environmental Control. Do you think that the thinking was when the regulation was originally drafted or amended that additional proof, DHEC needed proof for public health reasons because we're talking about wastewater sewer services? And so perhaps that was part of the reason for the 30 days versus a shorter period for wastewater? Because I want to talk to you after we finish, after you respond, talk to you
Mhm.
briefly about the two sections. I think they're in the 700, where there's a 10-day period and then a 30-day period. 735.1. But if we can first talk about, just wanted your thoughts on 535.1. Do you think that's reason? I don't know all of DHEC's procedures as it relates to disconnects for sewer services. But I was thinking, I said, well, maybe that's why the 30 days was included, because maybe DHEC has some additional work it needs to do to make sure that, for public health reasons, maybe they have some tie-offs they need to do. I don't know. Do you have any idea?
I'm looking at this rag, and it was last amended in 2007, but I think that amendment was only to reflect the Office of Regulatory Staff.
Yeah.
When we made that kind of omnibus change, I imagine it was a public health concern. I'm not aware of DHEC actually doing anything when sewer service is disconnected. Um, I mean, the reg requires notice, and obviously, cutting off somebody's sewer can have serious consequences. I mean, especially if they keep using it. Because we know, I mean, it's a plug, right? I mean, so what you're basically doing is saying sewage isn't going to leave the house, but it doesn't mean people can't keep using the facilities, and that can have drastic consequences if they do it. Um, I'm not aware of the DHEC component. It may be there, and then maybe that is, additional reason that maybe this is something we all need to talk about in a little more depth.
Okay.
Maybe even ask DHEC to come.
Yeah, I'll make that note too. And then, Charlie, over in 735.1A,
Mm-hmm.
you see where it says, service may be terminated for non-payment of a bill sent by regular mail to the customer's billing address that he has 10 days in which to make settlement on his account. And then
Mm-hmm.
B talks about service terminated for non-payment of any connection charge. I'm assuming that's like a tap fee, Charlie? I mean, a tap connection charge
Yeah.
properly imposed by the utility, and that's 30 days. So I think you're fine with B. Your client is fine with the way B is written and A there, because B requires
Well,
30 days notice.
they didn't say anything to me about B, and I suspect it's because that's probably not something that happens a lot.
Mm-hmm.
I mean, so it's probably not on their minds. If you asked them about it, they'd probably say conform it. But I doubt we're sending too many disconnects out for failure to pay I mean,
Yeah.
the tap fee is going to be paid before the service is started. So that's just probably not something that's happening a lot.
All right.
What they were saying is everything would work a lot more efficiently if we conformed sewer to water. Now, I feel sure that if you said, okay, we'll conform sewer to water by extending the disconnect period to 30 in water, they wouldn't be happy with that. And I'm not sure I'd recommend that either. I mean, we are dealing with notices of people that are already delinquent, right?
Yeah.
I mean, so again, stretching things out is not necessarily helpful to anybody.
Yeah. Yeah, I understood what you were saying about that too. I just, that thought came to mind. And then it's because another reason I was just reading, for example, under 535.1, it says, the DHEC, Division of Health and of Environmental Health of South Carolina Department of Health and Environmental Control and ORS shall immediately be notified of the action and the name and address of the customer. So, what we'll do is we'll look at another form. It shouldn't be as long, but maybe not maybe we'll invite DHEC just to see what perhaps they'll let us know their involvement as it relates to terminations and disconnects, and maybe clean that reg up if it doesn't need to. I don't know. Let's just have the discussion. That was one of my questions, Charlie. Charlie also wanted to know, do you know if your client leaves door hangers?
I'm not aware that we do.
Okay.
But I don't know, honestly.
All right.
I will just remind you that the commission, well, I don't know. I don't know if we do it or not.
And
I
also,
know the city does.
huh? What'd you say?
I know the city utility department does.
Yeah. And then
Not from personal experience, maybe, but
we, Charlie, also ask your client when we have the next forum, just to make them aware. I think we should all probably talk about electronic notification too.
yeah,
You know? Okay.
yeah.
All right. Thank you.
Thank you.
We're going to move on to the Department of Consumer Affairs. Roger Hall.
Good morning, Jocelyn.
Good morning.
Once again, we just appreciate the opportunity to participate in these workshops. It's been, I guess, touched on briefly. So I'll say that, we did submit some comments related to applications, particularly filing direct testimony along with the applications, submitting supporting documents, requiring uniform schedules, and submitting testimony and pleadings in Word or PDF searchable formats. Understand that will be discussed later on April 5th, so won't go into those much more other than just to say we submit them because we think they will improve efficiency and uniformity and create more thorough, informed hearings and ultimately final orders from the commission. And we also do support the commission's proposals for minimum filing requirements and of course think they should apply for water and sewer utilities. We had comments that have been discussed already on customer bill forms. Those briefly were to require font size be no less than 12 point, require headings to be in bold font, and prohibit the use of full sentences in all capital letters. We understand these are things that the utilities may not think about, but they are things the department thinks about, and it's part of our role in consumer protection. These are common items that our public information department tries to adhere to, as they're particularly helpful for older consumers and those that might have eyesight issues. We've heard some different comments about software packages might be an issue or bill size. I think what I would say to that is just we'd like to know is that speculation or are those can they show if they can show that this isn't possible or it's not feasible right now, that's one thing. If it's just again speculation that may not be possible, we would encourage the utilities to look into that and to see if they could improve ease of understanding for their customers. Let's see, our last set of comments, I guess those were our primary comments. I guess I would reply just to the Southwest Utility Group. We definitely disagree with their request to eliminate the 30-day notice of disconnection under the sewer regulations. And we would encourage the commission to rather align the to align the water, the shorter disconnect period underwater to align that with sewer, which does provide a longer period. I believe that's all of our comments. I guess the one other thing we did mention in the customer bill forms was to include ORS contact information there. And that's simply just so that consumer knows that if the company is unable to resolve their complaints, that they do have the option to call the ORS. I believe ORS, I'll let Mr. Knowles comment on that, but would support it so long as it says, yeah, you need to reach out to the company first. I believe that covers here. I'm just going to look at my notes real quick. Just keep this one brief. And again, we appreciate the opportunity. We look forward to the future workshops, and in particular the one to discuss applications. Thank you.
Thank you, Roger. So as you said, we're going to discuss again the rate applications on April 5th. But I have something I wanted to ask you. This is not show and tell today, but I wanted your thoughts after reading the department's comments regarding all caps. And I'll be right back. I need to pull something up on our Elmo and get your thoughts. I'll be right back.
Okay.
So Roger, this document is a public document, and I know we're discussing the commission's regulations right now, but your comments just, I don't know, I said, wow, that just recently happened. And so what I've done here is, as you can see, I use scissors and just cut any reference to the case because it's really not the issue here. The issue for me was some of the things that you just mentioned, the all caps and bold. Those are in actually some documents on our DMS, and this is a public notice, and this is not a reflection on any utility. This is a PSC notice. And Roger, do you mind me just asking you some questions? Because I know that, as I said, this is a discussion about our regulations, but anything that we can do on our end, the PSC, to help with readability, I think that was your point, and to try to further or more engage, if that is a correct phrase, the customer who is reading this information. That's what we want to do. Do you mind?
Jocelyn, I'd be happy to kind of comment, but I can't see what you're sharing. I don't know. I think it may just be on my end. I've got a notification that there's a low bandwidth or low.
No, I can't see it either.
Okay.
For what it's worth, if you pull up the live stream within a web browser, you can view the Elmo. It's a little bit of a workaround, but it seems to work.
No, that's a great idea. I'll do that right now. Okay, Jocelyn, yeah, I took Sam's suggestion, so I can see what you have on the screen now.
I really appreciate you doing this workaround for me. I really do. But I hope you don't mind me asking this, because whatever we can do to help, make sure that that people feel as if, or that they are more engaged. I'll use that phrase again when they read notices that are issued by the commission. So, Roger, for example, this is from, as I said, I cut any reference to any case. I tried to use my scissors and cut that information, remove that information from this. And I think I think that maybe the thinking here was that the all caps would draw the eye, the reader to the information. Like it's important information. But is this an example of based on your department's experience and, for example, your customer service division, that this might not necessarily attract someone's attention?
Yeah, and I think it's a great example. And just full disclosure, this is not something that I had thought about personally before speaking to our public information folks. And until I read the explanation that we included in our comment letter about shapes of letters um, that I thought about, but now I notice it all the time. So again, I think, and maybe you have as well, when you read that, it's easy to lose your place in there. It's easy to kind of the way your eye and brain functions. It's kind of the way I've read it is that your eyes are sort of are scanning ahead, and your brain is kind of comprehending as you get to it. So it just kind of creates confusion. It creates just again for ease of readability and comprehension. They the experts, not me, suggest that we not use all caps for long sentences.
Okay. All right. So nobody should be offended. This is the PSC's document. So anyway,
But you're right. Bold,
thank you.
Bold does draw the reader's attention to things like headings and that. But it's mainly this all caps for full sentences and important information.
Okay. So bold draws the based on your what bold draws the attention, but it's the all caps and full sentences might not be as effective. All right. Thank you. Let me Melissa, can we switch back? Thank you, Roger. And Sam and Charlie and Alex, I hope you don't mind that I asked that, but sometimes you have to start at home.
No worries.
All right, Roger. I think that's all I have, Roger. Thank you. We look forward to talking to you and Sam and Charlie again on the 5th. Alex, if we can move to you.
Sounds good. Good morning, Jocelyn.
Good morning.
So I was planning to just highlight two of ORS's recommendations here, although I may start out of order and address some of the comments relating to bill forms. ORS doesn't take a position on those, but our consumer services folks have asked that if the commission were to require ORS's contact information to be added to the bill form, that some additional language be added to advise the customer first contact the utility. And I guess I would also note that ORS's recommendation on, Regulation 730 would require the utility to immediately advise the customer upon receipt of a complaint that they can contact the Office of Regulatory Staff as well. So there's been a lot of discussion about the notice relating to discontinuance of service. So ORS does recommend that the utilities be required to provide an additional notice in the 2 to 3 business days prior to discontinuance of service. I think that, Jocelyn, a lot of the points that you covered in the discussion with Sam, ORS would agree with. Don't think that there should be, we read the language of alternatively allowing the mailing to provide that mailing as an alternative. We wouldn't oppose retooling the language if there was room to make that more clear. In general, ORS does support just providing customers with ample notice. So that's really the point. And we're on board with, essentially empowering customers to receive notice in a way that works for them, that is most likely to reach them, and we don't want to restrict the utility and how it can provide notice, as long as the utility is providing notice in a way that is meant and likely to provide the customer with actual notice. So I think that's what I would say about that. And let me also just mention ORS's recommendation again relating to the procedures for termination of service and notice prior to discontinuance of service. That ORS has recommended updating these regulations to provide customers with the ability to designate a third party to receive disconnection notices, as is currently allowed for electric and natural gas customers. And we would just note that this third party notification option can make a very significant difference for a customer who might have medical or special needs, who might be uniquely adversely impacted by an otherwise avoidable shutoff. So that's what I have to say, I think, about our comments in chief. Happy to address any other comments that ORS has made that you might have questions about. As far as ORS's reply comments, going to Southwest recommendation relating to eliminating the initial 30-day notice requirement. ORS doesn't object to Southwest's request to eliminate the certified mail requirement. In fact, we tend to support it, but we do understand that it could be a little more complicated issue, and we wouldn't be against exploring that further. But I do want to note that ORS does oppose eliminating that notice requirement entirely. So that wraps up my summary of ORS's comments, and happy to talk further about any questions you have.
Thank you so much, Alex. I just had a few, if you don't mind. So, I was just curious for the 103-730 customer information. Are there any particular reasons as to why ORS is recommending deleting that remains unresolved after 7 days? Do you think that's insufficient time, too much time?
It's not that I've been made aware of any particular issues that customers have had. It's more just to more promptly advise the customer about ORS availability.
So you just feel the language is.
Oh, sorry. Go ahead.
It's just not necessary. Is that what you're saying? Notify any customer making a complaint pursuant to 103-716. The utility is under the jurisdiction of the commission. You just think it's.
Yes, ma'am. That's right. And so I guess I would say then in response to your question that we think more quickly advising the customer of that is preferable to waiting the 7 days.
Okay. Thank you for that. And then, do you know if your client would be opposed for the oral limitation in 103-538B and 103-738B, where ORS recommends removing the word oral? Do you think the language, the regulation would be too wordy if we state oral and or written, or oral or written? Or do you think that it would be, so the phrase we're referencing is when the ORS has notified the utility that an oral complaint has been received. I guess that's the only way you would receive it, potentially, oral or in writing.
those are the only two ways that I can think of. Yes, ma'am. So I guess yeah, we had thought that eliminating oral would be more concise, but if the commission thought it would be better to specify oral or written to avoid confusion in the event that there was some other possible situation, ORS wouldn't have any opposition to
You don't
that.
think, okay, if you need to, if you change your mind, just, write us and let us know. I just thought about, I don't know why I did, but that came to mind, maybe ask you about just, including the words or written, so oral or written.
Copy that. Thank you.
But if you find it, you're opposed to that, you can let us know. And then you answered the question, hopefully Mr. Wellborn, the question I had about the alternatively language in 103-535.1, excuse me, and 735.1, it's an alternative. They don't have to provide notices, both alternative notices.
That is what ORS had intended to recommend. Yes, ma'am.
Okay.
And again, if there's room to clarify that, we're open to it.
I don't know. I don't know, Alex, if alternatively or in the alternative, I don't know. We can think about that. So it's clear if that's what ends up being recommended. And let me see if I have anything else. Oh, I did. But we're going to talk about the rate case applications later. That's all I have, Alex. Thank you.
Thank you very much.
Jocelyn,
Yeah.
this is Sam.
Hey,
May
Sam.
I ask a question?
Yes, sir.
Since we're talking about addressing the rate case application piece later, I wonder if it wouldn't be, or when the appropriate time to ask whether the rate case application requirements in Articles 5 and 7 would need to be eliminated or removed from those articles. But maybe we hold that, I guess, until we've talked further about rate case applications more generally. What do you think?
No, I think we should perhaps, don't you think we can modify our notice to say we're going to talk about, so we'll go back and look for all the sections dealing with rate applications. That won't be difficult. And just modify the notice. It could be that we end up having 2 sessions. They won't be long on the rate applications, but I think it might be wise to talk about all of them at the same time because it's pretty much, I think the language is very similar.
Yeah, that makes sense to me. I think not doing that, I would be concerned that we would have overlapping requirements that apply generally and then also to water and sewer utilities. So I think that makes sense to me for whatever that's worth.
Right, and maybe we can, when we get to that point, leave the section, but only say, for rate case application requirements, see the commission's practice and procedure regulation, something like that. So we would just leave it, but then point the reader to the 800 series. Just a thought. But I think we should talk about all of them at the same time. Okay?
Not to be difficult,
Go ahead, Charlie.
but we're actually going to recommend that you break, which you've already done, is you've got separate requirements proposed for water. I mean, I don't care which article they're in, but I think discussing them separately instead of lumping the discussion of the water companies in with the power companies would make a lot of sense to break these things apart.
And we would support that too, Charlie, for what it's worth, having a distinct conversation, just given the different natures between utility, electric and water and sewer.
Okay. So everybody, let's do this then. I think we will talk about on the 5th, the minimum filing requirements, just where we are at that point. And then we'll come up with another schedule to address the 500 and 700 series rate applications. And then the whatever other series we have.
That would be great.
But let's proceed where we are right now with the information everybody has right now. And then on the 5th, we'll wait until the 5th And then let's come up with a plan of action moving forward to address, because some persons, there might be some interested persons who want to know how, the future dates for discussing the other series, and also how we might be most efficient doing this, how we might most effectively accomplish this. So we'll start where we are, and then we'll discuss all of this further as it relates to rate applications for all the sectors on the 5th, and future dates, future workshop dates. Is that okay?
Thank you.
Okay.
Yes, thank you.
Sounds good. Thank you.
Okay. Roger and Alex, do you have anything else?
No, nothing here, and I'm fine with that approach of separating those out eventually. Obviously,
Okay.
there will be different requirements, I believe, for water and sewer companies versus electric companies.
Okay. Yeah, because I think that once we start on the 5th, who knows where those discussions will lead. And we could change our minds on the 5th once we get our brains back working again on the 5th.
Mm-hmm.
Okay. All right. Does anybody have anything else? You okay, Cindy? All right. Well, everybody, thank you again. I hope that you have a great weekend. Thank you for participating today, as always, and we'll see you on April 5th.
Thank you.
Take care.
Bye, everybody.